Welcome, everyone, to this Tuesday, April 27th, 2010 edition of Money Banking and Trust by Moving Titles and Commerce. And welcome to NTT as New Trust Technology. I'm your host, Christian Walters, and today's the Tuesday Q&A, so we'll just get right into questions and answers. So anybody has a question? Press star 6.
Hey, Christian.
State your name, where you're from.
This is Joe from Southern Nevada.
Hi.
I sent out that 9-210A4, and they didn't respond in 14 days, and then I did a protest and notice of dishonor and give them another 10 days. And I received a letter from a lawyer representing them, and they said that the validation request wasn't properly authenticated. You know anything about that?
Well, if it wasn't properly authenticated, they're talking about, was there acknowledgement on the jurat?
They said that they were going to send the paperwork shortly.
Well, that's not good enough. They only have 14 days.
I don't have to give them the extra 10 or whatever because of the protests?
In respond, according to UCC 9-210, they have 14 days to respond, and that time they could have asked for an extension. They never asked for an extension. Therefore, the matter's been closed. It's certified by the notary. They're in default. It's dishonor. It's certified by the notary, period.
Even if I had the notary send them an additional, like, dishonor and gave them an additional 10 days and they responded within the 10 days?
Well, if you extended the time, yeah, that would make a difference. But they have 14 days according to UCC. So you gave them an additional 10 days? Or how many days total did you give them?
The 14 plus 3 days going and 3 days back plus additional 10 days.
And that was the opportunity to cure?
Yes. Notice of dishonor. And then I was going to follow it up with an affidavit of, or notice of cure and notice of default, right to cure, and then have a certificate of protest drawn up. Like a good faith gesture.
Yeah, as long as you had an opportunity to cure in there and you gave them the 14 days, and then after the 14 days, an opportunity to cure, 72 hours, 3-day period. If they didn't send anything under the opportunity to cure, then I would have the notary certify the dishonor. And from that point on, it doesn't make any difference whether they send it. It's all late, it's untimely.
Yeah. Okay, I'll just see what they send and see what goes on.
So is that within the time frame? They're sending it within the time frame?
Yes. That I gave them.
Even if they do something, chances are that they will validate what they send. They're probably going to just send you copies of what they sent you before, which does not qualify.
Under Rule 602, first-hand knowledge.
Yeah, well, that's for validation. That would be, they have to swear to it. Somebody put some penalty and perjury statement in there that makes them liable for what they say. That way, when they don't respond under certification, verification, they're not validating the debt, really. They're just rehashing something they sent to you again. And that doesn't qualify as a validation of the debt.
Well, this is like a lawyer handling this, so I assume they wouldn't have first-hand knowledge because everything that's presented to them would be hearsay.
Right. You're probably going to get just copies of what you've been sent previously. Or just a rehash of the same old information. You owe X amount of dollars, and this is a debt validation. To attempt to collect the debt, I mean.
Let me ask you another question. Since I live in Southern Nevada, and you talked about that case, that bankruptcy case here in Nevada, NRS statute 107.020, stating that the signer of the note is the grantor. Can I use that, or do I have to go to the Social Security and do the SS5 form? Or?
To do what?
To claim as the grantor, or I suppose I would have to.
Well,
or can I use that statute?
As long as I got two forms of evidence that proves that I am, that statute is just pointing to there's where your source of information is that you need to go to. If you don't want to sign, you're the grantor on the note. You're the maker.
And that'll yeah, okay.
Who signed the note? Whoever signed the note, that's the grantor.
Right.
The note itself is the evidence.
Okay, thank you.
All right. Anybody else? Question? State your name and where you're from. *6 to unmute. Yeah, Christian, this is Floyd. Floyd, how are you tonight?
Good. I filed my UCC-1 today in the state of Washington, and I was looking on the site for the UCC-3 to file it online, and I cannot find where you file the UCC-3 online. And I was wondering if anybody out there had the same problem, or if they would know where to go on here, because I had no trouble pulling up the UCC-1. But the only thing I can find on the UCC-3 is one that you fill out and print it and send it in, mail it in, which I suppose would be okay, but I'm not sure. It probably costs more money to do it that way.
Okay, I'm not familiar with the filing in Washington there, but yeah, is anybody else familiar with it? Maybe you're not looking in the right spot, maybe.
Christian, can't he just go ahead and use the UCC file number out of Washington and do a UCC-3 within his own state?
Yeah, I suppose it could. But the thing with Washington was that was the international office, I believe.
Yeah. Yeah. Floyd, if you want to try to work with me on that, I actually have to learn how to do that in Washington myself tonight. If you want to get in contact with me after the show, we can walk through it and identify where the UCC-3 files are.
Well, it doesn't even name the UCC-3 file. It does the UCC-1. It has a place for filing, but it doesn't have any place for transfer.
Okay,
right, let me go look.
It might look for UCC-3, but it might be listed, say, under an addendum.
Yeah, let me go look for it. I'll be right back.
Yeah, I looked under addendum.
Oh, you did?
I looked under, well, the only thing there is amendment.
Okay, maybe the amendment might be the one they're going by.
Well, that's a good possibility. Let me go back in there and see.
Probably one of those forms is, the form that you need, but it's maybe going by a different name there. You're not identifying it right, maybe. Did you get the nomenclature for the collateral block last night?
Pardon me?
Did you get the nomenclature for the collateral block last night?
Yeah, I did. Pete sent it over to me.
Okay, great.
Yeah.
Didn't you get the one that I sent to you in an email?
No, I never got your email.
Lloyd. Well, that's why I was asked why didn't I send it last night. I did send it. I probably had the wrong email address, or I can't remember what it is. It's on a different tag right now. Sorry about that.
That's okay. Where there's a will, there's a way. Yeah.
Anything else, Floyd?
Not right at the moment. If I think of something, I'll I'll come back in because I've been working on this, and I did change my my indenture a little after I talked to you. So I guess maybe I could read. Well, let me see if I can pull that up. And
Okay, go ahead.
just hang on a minute here. I got to go into my thingies here. Okay, and let's see here. I got so many windows open here; it takes forever. Okay, what I did on my purpose, I shortened it down. I shortened it, and I put on the purpose. It is the purpose of the trust to hold the principal of the beneficiary in confidence until further notice for future return with his interest, or in the alternative until other instructions are given. These instructions may be changed from time to time by the beneficiary. Was that your suggestion? And I did that.
Okay.
Okay, and the intent, I put, it is the intent of the grantor to relinquish back to the beneficiary the equal amount of the prepaid benefits charged by Sprint Corporation in the services provided by Sprint in the public. I took out all that other stuff like HGR 192 and 1933 and all that stuff.
Right.
So that kind of slimmed it down a little bit.
Read that last part again, where you talk about the charge.
It is the intent of the grantor to relinquish back to the beneficiary the equal amount of the prepaid benefits charged by Sprint Corporation and the services provided by Sprint in the public.
I don't like that.
Okay, what would you do to change it?
Relinquish back.
Yeah.
What would you say? Relinquish back the charges. Say it again.
Relinquish back to the beneficiary the equal amount of the prepaid benefits charged by Sprint.
What would be the terminology that by which the beneficiary gets his money or his property?
What would be the
Trust term.
Trust. The only thing I can think of is res.
Disbursement.
Oh, disbursement. Oh, okay, you're right.
You give them an instruction to disperse the funds to beneficiary.
Okay, so it's the intent of the grantor to disperse back to the beneficiary.
Okay, but what is he dispersing? Is there going to be an overage here?
Well, actually, it's going to be at least the same amount that Sprint is charging. So there will
not going to get anything then, right?
Well, what I'm doing,
he gets his bill paid. He gets
the bill paid,
right?
Yeah. That's the purpose of this. I mean, that's the.
So why are we dispersing anything or returning anything to the beneficiary? Because he's not getting anything except for the use.
That's true. And that's really what I want. Is I want the use of the service.
Okay, but that's not what you're saying.
Oh, I'm not.
Not that I can see.
Oh.
Read it again.
It is the intent of the grantor to disperse back to the beneficiary the equal amount of the prepaid benefits charged by Sprint in the services provided by Sprint in the public. So what I'm doing is I'm equaling everything out here.
Confusing.
Yeah, because he should be using settler in that particular case if he's going to act as trustee dealing with the trust, you're going to have to act as a settler rather than a grantor.
So this is for the follow-up instructions. This is the second setup that you're sending now to the instructor.
This is in my private. This is not even given to the. This is not given to Sprint. This is not given to anybody. It's only used in the event that I go into court to prove that there is a trust.
Oh.
Because my follow-up is different. In other words, my instructions, I'll read you my instructions that I send in with the bill. These are instructions along with a special deposit of April blank 2010 to the remittance form of amount due by May 2nd. Hold my principal until further notice for future return with my interest with great care by grantor, Lloyd Bradley Howell.
Okay, that's the first sending, right?
That's the first sending, yeah.
That's going to form the trust.
That's going to form the trust, yes. And then the deposit follow-up is apply, okay, for special deposit follow-up.
Did you amend, could be amended from time to time? Or are you going to put in there for instructions to follow or something like that?
That's right, I didn't put that in there.
Mm-hmm.
Okay, I can put that in there.
Just tell them, hold this until further instructions.
Okay. Then my instructions for special deposit follow-up is apply the total special deposit of April blank 2010 to the amount enclosed on the amount due by May 2nd form dated April blank 2010 by beneficiary Floyd Bradley Howell. Now I put beneficiary instead of grantor like last night.
Read that again, which is just
apply the total special deposit of April blank 2010 to the amount enclosed on the amount due by May 2nd form dated April blank 2010.
I hereby order, decree, or direct you to.
Okay.
I like order. I hereby order you, or I hereby direct you, or command.
Okay.
I order you to do blah, 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 you said.
Right, okay. I order you to apply the total special deposit of April blank 2010 by May 2nd form dated April blank 2010. Okay.
I probably have to give them an order just to convert the asset into usable funds and then apply it towards the debt.
Okay, would I put that in my first instruction?
This is the instruction you're giving them, to take what's already on special deposit. Now I order you to convert it and apply it to the debt.
Oh, okay. Convert it. I order you to convert it and apply. Okay. All right. I'll change that right now. I order you to convert and apply.
Lotus, JC, I had a question for you.
Yeah, go ahead, JC.
When you're filing electronically in Washington, because I know a lot of people do that, how are you modifying their blocks so that you are declaring your proper status and not simply as the debtor-creditor side?
They actually have
Where are you?
they actually have places in there for trust. And then on the bottom, in the number 8 space, you put trustee, trustor.
Okay, so there's a single checkbox, not Bailey Baylor, but it says, or it applies to trusts. So you designated that as a trust filing?
Yes.
Okay.
And then let me see here. There's one place where actually you're putting that they are that the debtor is the trustee with holding res, trust res. And that's a little pop-up deal that you can punch in.
Okay.
For trust deposit on Black's Fourth Revised, where money or property is deposited to be kept intact and not commingled with other funds or property of bank, and is to be returned in kind to the depositor or devoted to a particular purpose or requirement of depositor or payment of particular debts or obligations of depositor.
Okay, what section is that? What section is that?
That's Black's Law, Fourth Revised definition of trust deposit.
Oh, okay. Hey, Christy, can I ask you a question?
Yeah, go ahead.
Hey, this is George from North Carolina. I'm working on a foreclosure. However, this is a house that I purchased 3 or 4 years ago. I don't know if you're familiar with the term subject to the existing mortgage, but basically the mortgage is still in the name of the original owner, who has since moved to Florida. I live in North Carolina. He's moved to Florida. I have no idea where he is. But I have his limited power of attorney to handle any kind of business regarding the property. So my question is, are there any issues around signing his name to, let's say, a UCC 1 or 3 to try and get the foreclosure stopped?
Well, how are you going to use the UCC 1s and 3s?
Well, I thought what I would do is as you've described, is to, take the note and claim it and then transfer it into trust, and then try to, put on the protective order, and then basically, order the note to be returned.
Well, if you have power of attorney over the affairs for that particular instance, then you've got the power to go ahead and do what you need to do.
Okay. Is there a problem in just signing his name? Do I have to, agent, POA or something? Slash POA?
Yep, it's going to be in their realm. Yep. It's got to be done separately like they're used to seeing.
Okay. You know what? What section of UCC that's covered in? Okay. Great, thank you.
I would think you'd have to do some kind of public notice that you're going to, unless he responds affirmatively that it's not okay, and create a record that he was noticed.
The power of attorney I've got was recorded 3 years ago in the public registry, and it's an irrevocable power of attorney. He can't revoke it.
All right.
And that gives you authority to sign his name for generally or especially for limited purpose?
Limited purpose to do anything with regard to the property.
That seems fair then.
Okay, Floyd, you're back on?
Yeah.
Okay.
Yeah, I'm here. Okay, I went back into the instructions with special deposit, and I put in, I already hold my principal until further notice for future return with my interest with great care. And then there was something else that you said, or special notice or something like that.
Hold it for further instructions.
Okay, well, I put further instructions to follow. And after that, okay, I order you to hold my principal until further notice for future return with my interest with great care, period. Further instructions.
Why do we need in there for further notice?
Okay, let's see. I order you to hold my principal. Okay, I guess I don't, because I'm just repeating myself, I guess. I order you to hold my principal for future return with my interest with great care. Further instructions to follow.
There you go. That's even simple. I like to help you.
Okay. Oh, okay. Well, this is the first time I've done this, you know. Okay, I'll take that out. Let's see, hold my principal.
And then next time you're going to send the instructions in.
Yeah.
So in between times, you'll have done the 1 claiming the trust or having the information that you formed the trust.
Right. I've got the 1 and the 3 that I'm working on now, and then I'm going to take my indenture and I'm going to get it notarized. And I'm going to take my 1 and my 3 and put it in the county, notice it in the county. And in the meantime, I'll be sending all of this to Sprint and getting that taken care of. And I should do that in the next day or two.
Yeah, you could probably send the first set of 1s and 3s in the counties along with the instructions.
Oh, you actually send the UCC1 with your all your information.
Well, you might want to keep that the UCC1 that's just your claim. Yeah. 3 is you transferred this property, say, 1 week earlier.
Oh, okay.
And then send that along with the instructions what to do with the trust regs.
I see. Okay. All right. Well, then I'll get the 3 done. I'll try and get that done tonight then, and then I should have that to send out this week, or the next day or two. Okay. And then that should take care of everything, right? And that should be the only thing I have to do now.
What's the instructions again?
Well, take the, okay, I order you to hold my for future return with my interest with great care. Further instructions to follow.
That should be with the first step. We're talking about instruction, which is the second step, right?
Well, the second step would include the UCC.
Right. But what's the instructions? Because they've already got trust res. They're sitting there holding trust res. Now, what's the instruction that you're sending now? Say 1 week after you did the deposit, the special deposit. Instructions.
Okay. order you to convert and apply the total special deposit of April blank 2010 to the amount enclosed on the amount due by May 2nd form dated April blank 2010.
That's good.
Okay. And I can send that out the next day.
Yeah, you don't have to wait a week. Yeah.
No, I want to get this all done before May 2nd.
Except how do you know when they got it?
Pardon me?
Except how do you know when they got it?
Well, I'm going to be sending it registered mail. With a
Okay, still doesn't tell me how do you know when they got it.
Well, when I get my green card back, then I'll know that they got it.
Yeah, that would be proof when they got it, but does that say a date and time on there?
No, I don't have a date and time on here.
Okay, how do you get a date and time so that you know when they got it?
Isn't there a form that you can put in with your mailing?
Well, you could go to the post office and they would tell you what it was, or you could go on the USPS website, punch in the ERA numbers, and it'll come right up on your computer screen what time it was sent, what time it was received in that area, what time it was delivered, and what time they signed.
Okay.
Well, that's one. See on that screen they have signed for it, and I know they've got it. Then I would send out this second instruction.
Oh, okay. Okay. Because I know that
when does the trust form?
When the trust forms, when they deny or refuse or do whatever it is that they're going to do.
No.
Well, I've already formed the trust.
How did you form the trust? How do you know the trust was formed? What forms the trust?
My filing.
No, that's just notice that you formed a trust. That's not the formation of trust.
Well, when I
think all I got to do is file some forms into the trust. That I don't have to file those forms to form the trust. You don't have to file a UCC3 to form a trust.
Well, you can form a trust just by declaring a trust.
Yes, right. So what is it that forms the trust?
My intent and purpose.
No. That may be part of it.
Well, my signature does. I know that. My signature is involved in it.
And what is it that actually is the manifested intent of the formation of
the time at the time that I intended to do to form the trust?
That doesn't form the trust.
That doesn't form it.
No. Okay. Will they help him out?
Yeah, Floyd,
Is there something about transfer in there?
Yeah, Floyd, when they receive the res, that's when the trust is formed.
Correct. When they receive the res.
When the res is transferred?
No.
When they receive the res. They have to receive it.
When do you know that they got the res?
Oh, so when they receive the res, that's when the trust is formed.
Yeah, you got to have when the trustee receives the res, the trust forms.
That's why he's asking you what in time it is, because that's how you know if the trustee has received the res.
So I want to make sure that the trust is formed first, and then I can follow up with the instructions or do something else. That's why
Okay.
it's critical to make sure that they got trust res, and that's why I said check on that website and make sure when they sign for it, because when they sign for it, then you got some kind of evidence created that they got it.
Okay. Well, I know that I talked to the post office the other day, and the postmaster said that whenever with the registered mail, whoever handles that has to sign for it, and so it's signed for more than once if it goes through more than one handling.
Correct. Yeah.
That's how you know where it is along the route, right?
Uh-huh. It has to have an unbroken chain of succession there.
Okay. Okay.
Now,
So,
is there a specific way that you can say, okay, it's for trustee so-and-so, he has to sign for it personally?
I suppose on the card there is, yeah.
Yeah, I think there is a block that you can express that it has to be that person and that person only that signs.
Right, and that would be, I think that's what you pay $1 extra for.
Yeah, $1 well spent.
Yeah, I know.
If anybody else signs for it, does that prove that he got it?
No.
Uh-uh.
Okay, and I do have the name of 3 trustees, so I'll put the CEO down as the trustee to accept it.
Right, so if that particular person signed for it, then you know that particular person got it.
Right.
And then I could prove that that person received trust rather than that's when the trust was formed.
Okay.
Christian, I've got a confirmation that it is the file an amendment that he needs to do. That'll get him into a whole roster of things under UCC3 that he can do. They're not naming it by UCC3. They just name it as amendment.
Yeah, that's what I thought.
Okay. So, but you went in on, you can do that online, Chris?
Yeah, I've actually got it right in front of me right now. You could do it's a filing of an amendment. You can do a select type of an amendment, termination statement, continuation, assignment, armed party information, change collateral, authority party. There's all kinds of things you can do under that document.
Yeah, it'll be assignment.
Yeah, that's right.
Yeah.
So what you do is you go in there and hit the help button, and it'll give you the pop-up menu. That's the quickest, fastest, easiest way to get to it.
I'll just look to that in our
Okay, I'll get that done tonight.
Real quick, what was the card verification code? Is that something that's supposed to be on the back of the card?
The card verification card?
Yes.
Not speaking, Chris, part 6 to me now.
Get out.
So we're talking about what block again?
Well, when you do the cash out, it's $11 to do a UCC1 filing there. It says a card verification code. It has to be something on the back of your credit card, isn't it?
I'm not familiar with Washington's filing up there, so
That
might be. So
Yeah, no, that just relates to the code on the back of your Visa MasterCard. It's a 3-digit number.
right.
Yeah. So there's an error in my process. I'm going to have to redo it. Okay, I'm going to mute out.
Okay, Christian, that's all I have for right now.
okay. One back on more.
Okay, thanks.
Yeah, Christian.
Yeah, go ahead.
Well, on Floyd's case, he has 3 people that he's naming as trustees or co-trustees. He's going to designate the CEO as a designated signer, recipient. But is it necessary or is it advisable to compel the other parties to sign as well?
No, not really.
So then one party can sign for the others.
Yeah, because he's got, however he listed on that green card, if it's a specific person, that party alone is only going to be able to receive it. But he's acting off as co-trustees, probably for enforcement, I suppose.
So how do we know that the other two parties will get the document?
We don't, but, one of the trustees has.
And so then we use the rule that it's not required, people don't have to know a trustee being informed. Is that what we're saying?
Right.
So then with respect to the trustee, disclaiming trusteeship, they don't have an opportunity because they have no notice.
Well, perhaps, since all three of them are in agency together, the agent to principal.
Right, so it would be the agency principal that if one knows, they all know.
Yes,
Okay. Thank you.
You might want to maybe send them notice once you send it to the first one, and you got record that he's received it, then send maybe the other two the copies of what was done. Now they have had notice.
Well, now, would that be registered mail as well?
Yeah. Mm-hmm.
Okay. That's what I was thinking, but, because I heard someplace that all the parties have to be notified, just for the purpose of the record.
Yeah, if you wanted to do due process, or you could work on the agency principal thing. It might be wise you could send them first-class mail, as long as they had notice, and you could prove maybe by certified mail.
Right. So we could do the U.S. postal system for them, and wouldn't take us out of the international jurisdiction.
Right.
Hey, Christian, if that's the case, why don't I put in notice to agent is notice to principal is notice to agent.
Yeah, you could do that.
I'll just put that in my instructions.
It still might be wise maybe to send certified mail the other two copies so that they got it.
Okay. This is going to cost me as much as paying the phone bill.
Oh, well, deduct it from the bill that you're making a payment for.
Yeah, right. That red pill cost me a lot of money. Oh, good. Well, I'll just chalk it up to a learning experience here. Education is expensive.
Yeah, or you could make it out for more, and then whatever the bill is, tell them to send you back the rest. That way you can take it out of the change.
Oh, yeah. Okay.
Floyd?
Yeah.
You don't necessarily have to do it, the way people are suggesting you do it with the UCC, but you can explore other ways to do it.
You just send them a love letter?
Well, we spoke about it last night. It's about noticing them to the public. It's just that the UCC is a convenient way to do that.
Yeah, there's other ways. Yeah. All we're doing is creating a public record.
Well,
so you can do it without it costing you a penny. If you need to keep hold of the purse strings.
Well, on the UCC3 that I'm sending along with the second notice, I have my email address on there, and if there's any information regarding this that needs to be gleaned, please contact the grantor at email such and such.
So you've already you've already paid for the filing, basically.
Yes, I've already paid for the UCC filing.
Yeah, okay, well, I'm talking about in the future event. You know, you can explore other methods, maybe ask a public notary, what methods can I use to file into the public domain, public arena? Because they know what it is, and they'll tell you, and it may not, you know, it may cost you nothing.
Yeah, our notaries over here, Pete, they're just no more than glorified agents for the Secretary of State.
Right, so...
They're not like over there.
Oh, I see.
These guys don't know anything. They haven't even read the statutes that they operate on.
So how about like a library or, you know, town hall or something? They all have public notices.
Yeah, there are different ways you could use other than just a UCC filing. Yeah, you're right there.
Yeah, I just think it's what's the word? You know, worth looking at for others as well who may not want to part with the cash.
Well, how much would it cost, Bryce?
The filing for Washington was only $11. It's not that much. I mean, unless you're going to do 10 filings, then it could get spendy. But I see how Pete did it on his. I mean, he put 21 filings on one UCC. So that was a smart way of doing what he did. I'm only doing this with Sprint just for practice anyway. It's not like I really, you know, $50 a month isn't all that big a deal. But I wanted to do something that I could get the practice and see where my weak points are, so that I don't have to get into a situation where it's really necessary for me to know something and I don't know it. So that's the reason why I'm doing this right now.
Start thinking.
So, but anyway, yeah, I could. I guess I could just write a letter to them, you know, and let them know that their buddy got a filing from me, and they were included.
Yeah, have that sent by a third individual that, you know, that's clean hands, arm's length, and then he could fill out an affidavit and swear that he did such and such an act for you.
Well, I have a notary public that would probably send it out for me.
Well, that's good. I mean, he could do a hand and seal under his authority. That he did such an act that he did it himself.
Yeah, you know, I would just pay for the stamp and then they'd send it out for me. So that'll be the least of my problem, you know, once I get this all done to notify the other two trustees, co-trustees, you know, that would be easy.
Oh, why do you want to do the other two? Just choose one trustee and save your pennies.
Nah, I wanted to put them all in there. Matter of fact, I even named Sprint Corporation as a trustee. So I wanted to cover all of the big shots, including the corporation. Well, I didn't want to leave them any wiggle room.
Christian, I'm not sure you can appoint a corporation as a trustee.
Well, I know you have to have the representatives of the trustee of the corporation, but I put the corporation in there as a cover or an umbrella, and named them as co-trustees in there.
JC?
Why can't you? Because a corporation is a person.
Right.
Yeah, and it automatically, by default, it goes to the CEO anyway, because they're responsible. So
Sure.
it can be the corporation in name, but, you know, it has to be the man who's operating it.
Right. Corporations can be sued, and they can sue, so they can certainly be a trustee.
Yeah, I think there's something called piercing the corporate veil, which is like a doctrine where, you know, someone is responsible.
No, the corporate veil is when the corporations can, so they do fraudulent acts. The purpose of corporations is to shield the shareholders and the executives against suits. But if the corporation or the members have committed fraud or some other violation of the corporate statutes, then they pierce the corporate veil to go after those individuals.
Yeah, well, by naming a corporation, he would be, in effect, making it public. It would be a public trust in the private between them and parties.
But all the names are public anyway because they're kept. The information is held in private, but you know the names of individuals are corporate titles.
Yeah. Floyd, can you read your instruction again?
Okay, let me pull it up again. I put it to bed.
Oh.
But it'll only take a second. Just hang on. Okay, you want me to read the first instructions, right?
This second one, actually is, the first one would be the indenture, the second one would be the instructions.
Well, I have the instructions, and then I have the follow-up instructions. The instructions now the indenture, I'm holding that. I'm holding that in private, and these are the instructions that go with my special deposit. And this is what I said. These are instructions along with a special deposit of April blank 2010 to the remittance form of amount due by May 2nd. I order you to hold my principal for future return with my interest with great care. Further instructions to follow. Okay? By grantor.
Does anybody have any comments or errors?
Yes, you didn't direct him to wait for the instructions. You just gave him a warning that there's some coming.
Yeah. Well, I told him to hold my principal, basically, until further instructions to follow.
Okay, then read the other part then, the second instruction.
Coming up right now. Okay. Instructions for special deposit follow-up. I order you to convert and apply the total special deposit of April blank 2010 to the amount enclosed on the amount due by May 2nd form dated April blank 2010 by beneficiary. And I sign my name.
Are we identifying the res specifically in any way? Because it says, the elements are, intent, purpose, parties, specific res. So is there a specific way we're identifying the res?
Well, I sent this amount due form, this amount due by May 2nd form, with an amount written in of $1,200 and some dollars.
How are you specifically identifying that res?
By calling it the amount due by May 2nd form.
Okay, what did you put in collateral block 4 on the 1s and the 3?
all I put in there was notice is hereby served by grantor as owner and holder of all rights, dues, and interests with the non-negotiable instrument bearing claim number RA number US.-0000 with all attachments and procedures therefrom as being held in the private.
The proceeds. Proceeds, right?
Yes.
Not procedures. Proceeds.
Yeah, my printer crapped out on me just as I printed this one out.
All right, how are you specifically identifying it, the trust res on that, which you just read?
By giving it a number.
Okay, now how are you identifying specific trust res in your document you're going to send them?
Let's see.
Tie the thing together, make it consistent on all forms so it flows through all the way.
Okay, let's see. I order you to convert and apply the total special. Okay, I'll tell you what I could do. Let me go back.
Well, let me ask you, what is the identifier of the res?
The number.
The RA number.
Yeah.
Okay, the RA number is on the claiming, the RA number is on the transfer. Why isn't the RA number in the instructions?
I didn't think about it, number one. Number two, I didn't, I thought that the RA number was only for filing purposes. So
well,
I didn't.
A specific way to identify trust res, and the elements is a specific trust res. So that would be a way of.
Yeah, that's right. I could put that on the deal that I'm using for my trust res. I could put that up in the corner, and then I could put that on the in the instructions, and then that would tie it all together.
Mm-hmm.
All I would have to do is just, well, let me see. I order you to convert and apply the total special deposit of RA number of April blank 2010 to the amount enclosed on the amount due by May 2nd form. That would give it more than one identification in that way.
But excuse me, but wouldn't it be? I mean, your bill has a number on it, right? Your account number, the phone number.
Yeah, but I don't want to use that because that number is their number, and I want to give them a number that I'm in control of, not them.
Okay. Gotcha.
And I don't know that number's not going to change anyway. I mean, I don't know what they're going to do with that number. But I know what I'm going to do with my number.
Right.
Okay, yeah, Christian, that's a good idea. I'm gonna do that.
I have a question for you.
Okay.
Why are you using words that are not really saying that it is a trust, then sprinkling in words that are specifically trust words? It's like, what are you exactly doing?
Well, number one, I'm learning what to do here, and number two, I'm expressing what I understand to be what I think that I'm doing. So I'm doing what I feel is, what I can understand and express. That's why I'm doing it the way I'm doing it. Now, I may not be doing it exactly right or correct, but if it works, then then I'll have learned that what I do is correct. If it doesn't work, then I'll have to figure out what I did wrong.
Well, we're all here trying to help you.
Yeah, I understand. And I appreciate it too, believe me.
Hey, Floyd, it's JC. I have a comment for you about that. You know, you're doing this as almost as a proof of concept, which I appreciate because everybody's out there trying to find and seek remedy. I think you may not know if you did it right or not right because they may not honor it, so you may have to enforce it. So it's hard to know. You might do all your paperwork perfectly the first time, but if they don't honor it, then you think you might have done something wrong.
Well, I want to do it in a way that I understand what I did, even if I did something not correct, so that when I go back and get after them for dishonoring a trust, what is that called? Anyway, breach of trust. Breach of trust, yeah. If I go after them for breach of trust, then at least I'll know what I did, and then I can act accordingly from that platform. See, if I did something that somebody said, "Oh, you have to do it this way," and I did it that way, and I didn't understand when I was doing it that way, then I wouldn't know what to do to correct what that person told me to do, because I'd have to go back to that person and say, well, why did I do it this way? See, the way that I look at this, it's a learning experience for each one of us individually, and I can see that there can be probably as many ways to do this as there are as many of you out there doing it yourself.
Right. There could be, but as long as the necessary elements are there for the formation of the trust, and one of the necessary elements there, and then one of the methods of formation, then the law will recognize that there is trust. That's really the only thing you need: the elements and the method of formation.
Right.
You can design the thing any way you want, as long as you got the elements in there and one of the methods of formation.
Yeah. Basically, I guess that's what I'm trying to explain. You know, that's why I've got trust grammar interspersed with the way I express things, which may not be trust grammar. Does that answer your question?
Well, I think what JC was trying to say is that after it's all said and done, you have to be ready to take the next step, which is basically filing something against them in court or a case against them, but maybe a cover letter of some sort can go along explaining that we know what they're doing, but the only problem with that, they'll still ignore it. So, because that's what I was thinking on doing, give them some type of a catchword per se, a colorable word saying that, a letter that we know what's going on here. And if you don't follow the instructions, then this is what's going to occur.
Right. And I agree that would be the next, because what we want to do is we do want to back them into a corner. And
you could just put in there and say, okay, please don't breach my trust.
Yeah, because obviously what I'm doing is creating a trust. I think they're going to get that idea right out of the box. And I really didn't hide that too well.
Can you guys not put an injunction on?
Yeah, I can. Yeah. Specific performance for not breaching the trust, yeah, you could do that.
Specific.
Or you could, if they did breach trust, you could go back in and enforce it from specific performance. Same thing.
Okay,
anyway, let's get to that step next.
Okay, would that be a good idea to put that in the instructions for a special deposit follow-up? Or do you convert and apply?
Personally, I would just see what they would do and see what comes up, because I could always send them a more nastier letter and threaten them.
Yeah, okay. All right, we'll just play it cool and be a nice guy for right now. See what they do. See if they cut off my telephone bill or cut off my telephone service.
That's a good point, though. That's a good point, because if they cut off the service, then that's like proof of reach, right?
Right, exactly, because now they haven't accepted the payment.
And on top of that, it goes back to someone suggesting that you put something else in your document saying that if you do breach the trust, then there are consequences. So let's say they turn the service off. Now, maybe it's important for you to conduct business or whatever. You're losing money, and then, they're liable for those losses as well.
Well, Floyd, if you want to, this is something that we've talked about for a while, is if you want to actually be proactive and really learn something, why don't you file an injunctive action against them proactively and just sue them and tell them and sue them that you want a declaratory judgment that if they shut off your service after having made payment in full by way of merging titles, that they're going to breach the trust and damage you, and therefore you want the court to demand that they don't breach the trust.
Yeah. How does that work, JC? How does that work?
Well, you're just asking the court to declare that if they breach this trust that's been put in place, that they're going to damage you, and you want them to basically enjoin them from not breaching that trust.
And that's injunctive relief?
Yeah, be a declaratory judgment, injunctive relief. You'll file for a preliminary injunction based on the creation of the trust, based on your essentially payment in advance of your 2 years of contract. It's already prepaid, but now they're on notice of that.
When do you do that? When do you have an injunction?
Well, what's the total amount of your contract? You could probably just file that. You could probably just file that in state court, your local state court.
Wouldn't that be putting a cart before the horse?
Not really. No, you're trying to prevent them from breaching.
Yeah.
So you file a case before they even do anything. That's what you're saying?
No, you're not filing a case. You're filing an injunction to compel specific performance.
Yeah, but I can kind of gather what he's saying is that what is your implication that they're going to breach the trust?
Well, it doesn't matter, because whenever the trust is formed, the eyes of equity are already on there. So all you're doing is, and it falls under the jurisdiction of the court. All you're doing is you're giving the information to the court to set the injunction, because the injunction's already kind of set. But now you can use that the injunction is set, and you can offer it to the trustee, and you can say, I do have an injunction on you at the court. So he's going to be less inclined to, close the phone line.
Well, let's take this on another step. I mean, what if the person that filed against Coca-Cola did what you're saying, and then they try to file an injunction, and Coca-Cola comes back and says, sorry, this is a trust. I don't have to do this because, I'm a trustee and I'm going to get myself in trouble.
Well, they're filing the injunction at the Court of Chancery, or the Equity Court, however you want to call it. Because that's where trusts are governed.
Yeah, but I think before I really filed an injunction, I want to have some kind of indication that it looks like they weren't going to do what they were supposed to.
Oh, it's just that here in England we can do it like even without any suspicion. We can just do it so it's covered, because the history of trustees.
Yeah, you can do that exactly. You can do it prospectively, because listen, if your phones are material to your business, and if they shut them off, it could damage your business so materially that
when they shut your phone off, then that was the reason for coming with an injunction.
Well, you're already damaged at this point. That's the point. You're already damaged, so you want to prevent the damage because you suspect.
Let's go back on his example, on Floyd's example, then we should maybe put some kind of time limit for them to credit the account.
Yeah.
3 days, 10 days.
Yeah,
well, 10 days is administrative. That would be the proper amount of time.
But that's
give them
different
10
law
days.
firm. Different law firm.
Well,
give them 10 days and then file your injunctive relief at the 11th day, because since they haven't adjusted your account, then you're seeking the court to declare that if they do breach that, they're going to be in default.
Yeah, that would be the thing. Check the account, see whether or not it was credited after the 10 days, and if it wasn't, then put your injunction in, yeah.
Well, the bill is due. The monthly bill is due May 2nd, and if I don't pay that, they'll cut that off anyway, 48 hours later. So I'll probably, in order to avoid that, I would probably have to pay that monthly $53, and then the rest of the month, then they have the ability, the chance to credit the $1,200 to the next 2 years.
Yeah, why don't you do it that way?
Yeah. Then that way I'll know that they didn't cut the phone bill up, the phone off for lack of payment. Right. Okay, here's a question about injunctions. I remember like they had the coal strikes and all those type of strikes. They put injunctions against the strikers. Right?
Yeah, I guess they did. I wasn't following that.
But I'm not for everybody. I mean, am I right on that? Because the strikers, they were compelled to go back to work. Or did they strike first, then they were compelled? How does that work? I mean, because some people are saying, well, you can't put the injunction on them, so they have failed to live up to their the commitment. Other people are saying
they had noticed them that they were allowed by a certain date because of the contract, so they knew that they were going to walk. But now they have grounds to come in and put the injunction in and make them go back to work.
Okay, so it's the same thing we would do in this case, as you said.
I would think so.
Well, I think that if I give them the chance to follow the instructions, and they appear to be following the instructions by doing something that I'm asking them to do, and I was sitting here thinking, well, what could I ask them to do? Just acknowledge that that in 10 days that this is going to be honored or something like that. And then at that point I'll know that I don't have to put an injunction against them if they honor it, and if they don't, then I'll start the injunction procedure. And would that be something you would include in your paperwork, that if they fail to comply, that you would just want to put an injunction? Would you tell them that? No. What I would do is I would just say, please reply to this. Please reply to this. Okay.
Why don't you ask them for a deposit receipt by such and such a date?
Okay. That's a good idea.
Send me a special deposit receipt.
Do you want to avoid purgatory language?
Yeah, that's what I'll do. I'll just say, send. Well, what Christian was saying was not precatory language. It was an order. Send me a special deposit receipt in 10 days from date of receipt of these instructions. That's clear language.
you have you're sending this information. Let's say that Sprint's the only phone company in the world, and they decide to turn you up. Can you in some way put in your documents that they can't do that? For failure of payment?
Well, they're kind of at a disadvantage here too, because if they breach the contract of 2 years, I can say, well, you guys didn't accept my payment. I now can I can now honor the breakage of the contract and not take Sprint again.
Right, but my question is, let's say there's only one phone company, Sprint.
Yeah, okay.
You have to have a phone. And what I'm saying is that, let's say they just say, well, look, you guys, like a credit card company, they'll say, well, we're going to turn you off, and so there you are with no phone. My question is, to everybody, can we put into this type of arrangement saying that they would be restricted from terminating without, due cause or something like that, just because they want to turn you off?
Yeah, you could tell them, that if you turn my service off, I'll meet you in court. I mean, that would be, and I mean, there's all kinds of things you can tell them, I guess, if you just take the time to think about it.
Okay, Floyd, when was the trust formed?
When they received the trust res.
All right, you haven't said that yet?
Let's see. Well, I have to put some more information in on this follow-up, like send me a special deposit trust receipt in blank number in days, 10 days date of receipt of this of these instructions.
Okay, so this is an existing account already?
Yes. Yeah.
How long have you had the account? How long have you had the account?
About 4 months, 4 or 5 months.
Does anybody see a problem here?
Yeah, he has to go back and say the date that it was created. That's when the trust started.
Right.
All he's doing is moving the titles, and that's the notification. And then doesn't he have to cancel the power of attorney that he gave them?
I would think so, yeah. Actually, the formation of the account, that should have been the formation of the trust.
Right.
And that code of contract that you've got now, Floyd, is what's probably going to hamper you. And that should have been the formation of the trust when you first signed or you first gave them authorization to start this account. Whether it's a trust account or whether it's a debit credit account, that's the question. So this deposits you're making now, that could be a special deposit, but you're forming that account on another account that's already been in existence. They may look at it as, well, you haven't novated this other account under debtor creditor into trust. So I think you might have to go back to the first documents that you signed and gave them authorization and turn that into trust. That should be the time when the trust formed.
Well, what if I would just put in my my paperwork, whether it's my instructions or whatever it is that that's what I could do is I could put in a notice of cancellation of any power of attorney that I may have given knowingly or unknowingly.
Yeah, let's back up. Did they send you a contract?
Well, I don't know if I have my contract. I moved from Wisconsin down here, and a lot of things have happened in between that I may not have. I mean, I may have the paperwork, but then on the other hand, I may not be able to find my paperwork.
Ask them
Is
for
there
it.
any way you find out when the date of when you signed the contract? Oh yeah, I can find that out. All I have to do is call them. All right. Have them send you some copies of that just in case you don't have it. But whatever date that you signed and that date, that's the date in your signature. That's when the trust was formed. That's what I would be putting on a UCC 1 and a 3. Well, actually, what I've already put on the UCC 1 is in private anyway. So whatever I'm going to be doing behind the scenes now, with after having filed this UCC 1, isn't going to change this UCC 1, right? Yeah, you're right. But the thinking is off because you're thinking that the formation of the trust is when you're making this first special deposit, which was 4 months after you really formed the trust. So you can go back and say 4 months ago, whatever that date was, and claim that as being when the trust was formed. Because all I have to do is put a notification in with my what I've already got created here, and once I find out what the date of that is, and just cancel any POA that I've knowingly or unknowingly given them.
Revocation of power of attorney?
Yeah.
Can you order a certified copy of your contract with the signature on it?
Well, I don't know if they'll give me a certified copy, but I'm sure that they would give me a copy, and I could go get it certified.
I don't think that would work.
So a signature would be your, say, the thing that they're using as the instrument. And that was like the non-negotiable instrument that you sent for your special deposit forming your trust, which the deposit copy, it's sending them back a copy that you turned this contract into a trust now.
Yeah, you need to get a copy of the original doc, and then you, like CW said, you intent, or you tell them that your intent was to create a trust then, and then you move the titles.
So in other words, what I do is I send a letter to Sprint or call them on the phone or whatever I'm going to do, and I'm going to ask them to send me a copy of my original contract with them. Yeah. Take that original contract and put a letter with it stating that this is a copy of my original contract that I intended to create a trust at the time of application.
Or express a trust.
Or just express the trust.
Right.
Okay. Yeah, okay.
Hey, Christian, one of the arguments that hasn't been brought up, or one of the discussions that hasn't been brought up, I won't make it an argument, is the Bankruptcy Act of 1933, and the way it was set up was an antitrust. So every corporation in some form or fashion has to be in alignment under their charters in regards to that Bankruptcy Act, of which says that dollar for dollar it has to be discharged, and any method is used as a tendered offer is an instrument to discharge. So don't you think that some of that language ought to be considered as part of the bankruptcy trust that we're in, and all corporations have to abide by it?
merging of titles.
You don't think that there's any usage or any value out of that for merging titles?
Well, there's really nothing mentioned in there about merging titles in House Joint Resolution.
Well, that's true.
Because the trust was created without him knowing it. Now all he has to do is revoke the power of attorney, declare that it's a trust and that was your intent, and then move the titles, and then tell him what to do.
Yeah, that sounds pretty good.
And then they have the responsibility and the knowledge to know that. I mean, that's their job.
I'll go ahead and I'll give them a call and get a hold of the business office or whatever it is I have to get a hold of, and just tell them to send me out a copy of my original contract
With your signature.
with my signature.
Yeah, suppose they don't send it with a signature. What would that mean?
That wouldn't be the original contract. That wouldn't be a copy of the original contract.
Because I would like to have a copy of what I at least signed, That way I could do some kind of enforcement from that copy. If I have no records, it's just like, all right, under UCC, under mortgage foreclosure, if the parties foreclosing they're claiming lost, stolen, or destroyed instrument, they must first prove that they had possession of a copy, or at least the original before that, to generate a copy from. So if you don't have a copy, that proves that you don't even have you probably didn't even have the original. So I think you'd have to keep a copy of what you signed. That way you could prove at least you had, something in your possession to start out with.
Yeah. Well, they should at least have that.
I would think so, yeah.
So I'll give them a call tomorrow and find out what they have and where it is, and if they can send that, and, get that over to me.
Yeah. Because that's when the trust really was formed.
Yeah. Then I can just go ahead with what I'm doing here, and I probably will have to change the dates on it by the time I get, everything together then. But that'll be no big deal.
Mm-hmm.
And in the meantime, I'll just make my monthly payment, and then that way I'll know that I didn't get the phone bill canceled because of the trust action.
Well, there's only one problem with what I see is that if they don't have, which more likely they don't have it, is the original signed contract. Would it not be fair to say that his initial first payment would also be considered trust res, a check?
Well, that's his second signature.
But there was a trust. Yeah, that
his payment on a first check that he sent them, but really his first signature was on the application.
Well, the thing is, what I'm saying is they're going to come back and say there's no trust here. Then he gets a copy of his original check with his signature on it and say, yes, there is, and here's the proof. And by the way, since you're in breach of trust because you've taken, without my permission, and put that into stock or an international market to make money off of without notifying me. That's what you went over last week, if I recall right.
Yeah. Mm-hmm. Yeah, is that mixing trust funds?
But is that JC who's speaking?
No, this is Michael.
Michael, but I have a question about that. Now, you're saying that they're going to claim there's no trust, but are not public utilities are they not trust by definition? Because they're like, you know what I mean? They're public utilities. They're public, so that there's a trust there, isn't there?
Well, the public utility is a trust, but thing is, your agreement between them and you is a separate trust. So their business is a trust, but they set up individual trusts or sub-trusts to each one of their customers. So you're not dealing with the public entity trust. You're dealing with the sub-trust, which is the original agreement between you and them. That's the trust that you're trying to use to make the payment.
Right. I'm just confused. I mean, you're saying that you're setting up a sub-trust with me or Floyd or whoever, but you're using the word trust. But that's what I'm trying to say. If they're a public trust, then, you know, and they're setting up sub-trust, then we're still in trust. We don't have to worry about them saying, you know, saying that there's no trust, because that's what they're doing.
Well, the thing is, it's the signature that's important for us to prove it, because the thing is, you know, we have already done some other things where we've sent, you know, A for B's and everything else, and we mentioned trust, and there's no trust form. What are you talking about? And even when you go into a judge's courtroom, well, I don't know what you're talking about. There's no trust here. But if you have a signature and they cashed it, the check, that's a trust. You have proof. Right?
I guess I don't know. So I'm learning from you. I don't know.
I think you can claim earlier than that. You know, it's your first dealing with them. It's, as Christian says, it's the authority that you granted for them to operate under your name. There's your...
Yeah, but the thing is, as we well know, that the authorization had to be done by either a signature or something for them to go ahead and do it. Okay, or you call up and say, hey, I want to start a trust. Okay, I want a phone in my house. I just moved here. Okay, well, you need to do this and make a payment first, $120 or $180 to set up an account. That's the initial, because that's what they're doing out here in Texas. When you open up a new account, they want a deposit.
Well,
so that's a special deposit right there into a trust.
In New Jersey, you have to do that. You call them up and say, I want a phone, and they come and they hook it up.
Well, they hook it. But the initial contact that you had between them had to be a date or a payment.
Well, it was a date, but no payment.
Well, the payment had to be made, otherwise your phone would have been shut off, right?
No, what I'm sharing with you is that they will come out without payment, put the phone in.
Yeah, but the thing is, if you don't make that payment after the first month...
Oh, right. I agree with you now, but I'm just saying you don't have to pay before you get it in. At that point, when you put the phone in, isn't that when the trust...
Well, that's when the trust is created, but the thing is, where's the signature? See, we're looking for a signature. Am I right, CW?
Yeah, it's a signature, right?
And the signature could be the payment. Right?
Yeah, it's whatever it is that we can claim and prove. That's what the res is.
My first signature was the one I'm after. That first signature, that's the one on the application. Now, if they took that application, treated it as a negotiable instrument, and they tendered that, and now they don't have it, then, okay, that still doesn't negate formed by the signature on the application, though.
Yeah, but things like he was saying, I mean, you make a phone call, hey, I want this, they take your Social Security number and all that and say, I want a phone. So the Social Security number is basically their initial signature. It's not our hand signature. We gave them authority verbally to go in and attach that account.
Yeah, but Floyd, you signed a contract, right, Floyd?
Yes, I did.
Okay.
Did you do a deposit?
In fact, I had to give them a $50 deposit before the first month, and at the time I signed up. Mm-hmm. So I do have, I'm sure that my bank has that check, and I can probably get the check, copy of it.
Now, what I'm saying, if they don't have the original contract, you've got the check that will back it up.
Right, exactly.
And it's obvious who's been making the payments on it. It's been him.
Mm-hmm.
Well, yeah, I've been making the payments with my debit card.
Yeah, that's fine because you got your monthly statements that prove that.
Right. Yeah. Whenever the date was, the formation of the trust being the date that you signed the contract, that would be the date that I would use as the formation of the trust. Okay. Well, I'll get that first and then hammer the rest of this stuff out, after I get it. Yeah. Yeah. Okay. That's my next step then. Get my original signature. I think we've been a couple other people have been on some calls in the past, and it comes back down to the same thing. We got to come back to the first signature. Okay.
Well, you got to get a certified. You got to get a certified copy of that, don't you?
Well, I don't know if they'll certify a copy, but yeah, if you could, that'd be great. Well, I'll ask them if they will, and if they won't, then I'll just tell them they'll send it out anyway. Because my signature on the first contract, that was my special deposit that formed the trust. Yeah, my signature was the trust for us.
Is there a rule that says if you sign something, you have a right to get a certified copy or not?
Well, they have to give a copy of the contract, which is basically, if you hang on to it, there's your certified copy, but they don't necessarily have to give you one.
I lost my record. Give me an extra copy.
A lot of times, like banks and stuff, they don't even give you a copy. They'll ask you to sign the signature card, and if you insure the financial agreement, they give you a copy. I mean, I noticed they told me I had a right to it when I pushed them on it. She acknowledged that. I was just wondering if there's a general law that if you put your signature to something, you've got to have some kind of right for a copy, at least, certified.
Michael, it's JC. I actually found that at least certain banks, once you sign that signature card, you had no rights to it as their property. And only one banker would even give a copy, but that's because I don't think she knew the corporate policy. The other ones who knew the policy, they would let you see the signature card on the screen, but they wouldn't print a copy for you.
Is that where you give them the because you've given them the power of attorney, and whether you knew it or not? Right. It comes back down to how did you sign? Yeah.
What about revoking your signature?
Well, you'll be revoking the contract.
Well, that's where you could use that ellipse that you were talking about the last few weeks. If you put the 3 dots there right after your name, then at that time you go ahead and create your own trust and put it down in an indenture with your intent, and therefore you've established what it was your intent to start with, and if it varies from theirs, then you have at least that much documents already done.
Well, that's preemptive. I'm just talking about existing ones where we haven't done that. But I'm thinking of something along the lines like a revocation and then a recontracting or new signature.
A rescission of signature.
Yeah.
Couldn't you just put in an amendment to the contract and tell them you wanted to revoke the power of attorney in that contract? I mean, you have a right to revoke power of attorney anytime you want, because you can fire attorneys anytime you want.
That's right.
And you want to keep the documentation tight on that. So you want to be recording your actions there and make sure that everything's done,
But you also got to correct your signature.
Well, there's really no way you can correct your signature other than doing it over again.
Got to do a revocation of power of attorney, then a rescission of signature based on something called that, and then a reissue of a signature, something along that line.
Well, I think CW, I think you're right. Is that even when JC said, and I'm thinking back, when I tried to get a copy of mine and they wouldn't give it to me, and that was years ago. The only way that you can basically do this is go in and cancel the account and open up a brand new one. And then at that point in time, you tell them, I want a copy.
Yeah.
And they give you a copy, because most people throw that stuff away, because the reason why they're not giving you a copy when the account's been going for a few years is because they know that if they release that information or give you a copy of that, you can move the titles. And that's what they don't want.
Well, I'm going to bet that they do not have the original with the signature on it, because they probably negotiated that.
Yeah.
So really, it's like almost your word against their word. And who's it come down to? The party that supposedly signed. What was your intent? Was it your intent to be under debtor-creditor, or was it your intent to have a trust?
But they've got the signature, and how are you going to verify your intent?
What is the manifestation of the intent of the grantor?
Non-pro-tunc.
So,
and is the records.
So, but how do you or deal with the signature without the by, the full column, no ellipsis? You know what I'm saying?
How do you deal with? Yeah, the ellipsis is what I'd like to see, on my documentation. I could really, nobody but myself is going to get me to change my mind that it was not my intent that this was supposed to be a trust.
So you just need to form a record of that then, perhaps.
Yes.
So that
And the only thing they're going to see is the manifestation of my intent, which would be my UCCs and my county recording. That's going to be the public records that points to that this is a trust.
Well, there you go then. So you don't have to necessarily cancel it outright. Just create it's almost like an update of your signature, just a clarification of your intent.
I would give them notice this is now a trust, and I might want to say revoke power of attorney. That they no longer have the right to sign for me that way.
And then you, in the letter that you send it, you non-pro-tunc it.
Yeah.
Would that create any liabilities for the other party, though, if you not pro-tunc it and create no complication? Would they go, oh, gee, then if you got to go back, that means everything that we've done, they might get, paranoid companies get with liability and everything?
No, because you're notifying this was my original intent back on this date, and you non-pro-tunc it right there. This was my original intent. And apparently you guys didn't understand that, so now I'm writing you something to let you know. And here's my notary to back it up.
By the way, here's my copies of the trust formation.
Right.
Yeah, okay.
But now when you say, here's my copies of my trust formation, if you don't have your original signature, just give them what you already have, and that would tell them that?
Yes, because really, if I just hand you my pen and say I want my pen back, that was a trust formation with my intent.
Yeah, they can't be liable for the signature though if they had no way of knowing up until the present moment. So I wouldn't even worry about the past signature then. It's just the focus is on the notice of clarification or whatever.
The manifestation of intent of the grantor that it was a trust. To concentrate on the records.
Yeah.
Straight up in the records.
Just a little. The idea just to make it a little bit easier than having to close the account down and renew it. That might be too much work. It's a lot easier just to update. Essentially, it's a form of updating the signature.
I don't think he has to close the account. I think he just needs to create the records of this as a trust and change his intent from, he just realized that it wasn't his intent to be debtor creditor, it was his intent to be trust.
Well,
Yeah.
in that letter, then that's where I would make a declaration that my intention now is to rescind any power of attorney that I have.
No. Skip all that. Skip all that. I think just go straight to the punch. It's your intent. Keep the focus on your intent. And that's even better than a revocation of a power of attorney, I think. Right, Christian?
Yeah, because that goes back to the beginning. When I signed the document, it was my intent. When I signed the document, this was intended to be a trust.
All that stuff just creates more complication and gets hooks that they can hook into. Now you just go straight to it, and that's my signature. Who's the other person who can clarify your signature?
Yourself. But what I was going to say is, then do I just put a cover letter in there over all these instructions and so forth?
Yeah. About clarifying your intent, or how do you phrase it, Christian? Just a notice of clarification of intent.
Well, like he said, he could make a declaration that this was from the date, say 4 months ago, from that date of his signature, that this was a trust.
Well, what I'll do is I'll call the company and ask them when I signed up for service, and they can give me that.
You know, you have to make sure whether or not they turn your service on such and such a date, but when did you sign the document? That's what you need to.
Right. Because then if I have a date that I can use, then I can clarify my intent from that date. Then I have something valid to use to lean on.
Right.
But what's
a copy of when you signed? You can't really prove. You don't remember exactly what date that was. The best thing I can say, they honor about such a date.
Yeah. Well, it was in December of last year, but I don't know exactly. Well, let me think. It probably was. Let's see. It probably was around the beginning of the month because
unless there's a copy that they can send you that shows you exactly when you signed. I don't know if you can trust when you signed. All you can do is come with an about.
Sorry, what's the importance of going back to the original date of signature if you're going to just reestablish and clarify your intent in the present?
Because really comes down to when did they get my signature, which was the trust res.
But if you if you establish
he probably didn't send anything. They couldn't tell you. So the best thing is, hey, on that was the date I signed it.
But I'm just trying to figure, for all practical intents and purposes, if you're now going to reestablish your intent or re-clarify it or give notice of some kind of clarification of what your now existing intent is, in case for whatever reason, misunderstanding or didn't realize you didn't sign properly, authenticate properly.
Misconstruement that you're under direct creditor and you're going to correct the record.
So what difference does the past make, as long as just basically the key thing is to create that document, make sure that you say it right, and make sure it gets get it, and
a letter of declaration of trust, and then make sure that you got the records that you got the UCC 1s and the 3s in the county.
And that's it. So you're just concerned about now moving into the future.
Right. And then you can focus on the special deposit.
Yeah. If they argue anything, you say, hey, didn't I clarify my intent here?
And this would be the second special deposit, because the first special deposit was the signature.
Yeah. And since he's already did a 210 on it, and they failed to answer him on that, he could say something in the language, by your failure to respond with the original documents with signature, I hereby am declaring that this is a trust, and then go from there.
I don't know.
Did you 9-210 on this?
Yeah, you said so earlier.
No, I never filed a 210.
I didn't think so.
Well, I thought you said you did.
No, when did I say that? I never said that.
But I just think it just the
210.
focus is.
I think what it was that you called out. Somebody did.
I don't have enough smarts to file a 210.
A4. Got it written down right here. Definition.
Everything just focuses on the that intent.
Right.
And when they try to take you up, because I mean that's the problem is when you start going on different tracks and tangents and arguments go out, just forget it. Just do you got my clarification of intent? Is that recorded or not? And I've got all the proof of registered mail when it got delivered and et cetera, et cetera. And that's it. Now you got to focus. That's the whole basis of your forward movement from this point onward.
Well, I'll go back and I'll find out when I sign the contract, and then I think I can handle it from there. And then I'll let you guys know what I'm doing. Okay.
See, I don't understand why he's got to keep going back to the thing if he's just going to, the only real issue now is the date.
The only reason I'm going to use a date, Shane, is for my benefit. I mean, it's easier for me to start from something than it is to just pull something out of the air and try to form around something nebulous. I just
the focus is right here, right now. The point of power is at present. It's your signature. You're the only one who can qualify it. And whenever they try and take you in 10 different directions, there's only one focus, and that's, have I not clarified my intent? Period. If he's,
I understand what you're saying. It's the way I have to do it. I want a number, and I want to start from that number.
Well, how about 0?
It's easier for me to form it. That's all.
Mm-hmm.
If for no other reason. But it's just
because if you create a notice of clarification of intent, does that not negate all past misunderstanding and records? And I just don't see it.
Well, I just want to look and know that I know now when we start a contract that it goes up for account, and that date that it goes back to.
I just, in the back of my mind, I just feel that if you go non-pro-tunc, that if it creates any consequences as a result of, it could be construed like, oh, this guy's going non-pro-tunc, lawyers look at it and go, oh my God, that means we did this wrong, we're liable for this, and I just see a potential. I mean, it'd be nice. And then they say, well, what if he's going to come after us for all that? And so I just think you're kind of creating a potential resistance, perhaps, because they don't realize you're just concerned about today and moving forward. And I don't know, I'm just throwing that out there, you know what I mean? I can't see how that's simple.
My cover letter will take care of all that. I mean, I'll word my cover letter so that there won't be any doubt as to what I'm doing. And I need a little time, when I'm creating something, I need a little time to think about it and revise it. I'll probably write this letter 15 times before I get what I want. And then Christian will, say, well, why don't you do this anyway?
Because I'm thinking now, after listening to this, because that would, just the way I think I'm going to go is if I create that one notice or letter, I think a notice would make sense, and something to the effect of, just off the top of my head right now, clarification of intent, which basically that subsumes the revocation of power of attorney. That's understood. And
title of this notice, declaration of intent, or notice of declaration of trust.
Yeah, and it's beautiful. I don't have to worry about, because I got accounts going back years, and I don't have to pay anybody, and I don't have to rely on other people to pull up documents for me. I don't have to do none of that. It's just, it starts from here now. I'm not worried about past, whatever's in the past. I don't want them to be concerned about it. I just want it to be from here. So that's it. And then, of course, because I'm doing that, to be worried about is the one I just created. That's it, I can't think of it simple.
If I had to go back 5 years with this, I wouldn't do it. I would do it the way you're doing it.
months or 5 months, it's no big deal.
Well, what about doing a clarification?
About being in the moment, the quantum. I think there's how, because going back and forth, it creates a lot of friction internally. But
all you're basically doing is you're just saying to them, look, you've made a mistake, what you're doing there, and here's my intent, here's what was supposed to have been followed. And that's it. And now follow it.
Because that's baggage was just saying, this is what it is now.
Yeah. Is that okay to say that, Christian, to say it was a mistake, or is it just better to say, I did not properly reflect my intent, keep it real clean and tight?
Well, really,
you
the grant has the part to correct anything on an indenture by mistake.
Okay.
Or how about may have been misconstrued? Instead of taking the blame onto yourself, this may have been misconstrued, and here's clarification of my intent.
Yeah, you're not really, they're both the same thing, really, because it was not my intent. That was a mistake.
Yeah.
Yeah.
I guess you can easily put it on their hands and just say, you made a mistake. Here was my actual intent.
Mm-hmm. I guess too, if you say mistake, then obviously that kind of, indirect way says, obviously anything that happened in the past, I'm not going to hold it against you, obviously. Because it was you're saying it was your mistake.
Well, still be that it's been misconstrued and it's their mistake.
Yeah. But you're the one who signed the signature as such. You can't blame them because you signed your signature in a way that they had no other way to interpret it but a power of attorney.
Yeah, but they know your intent? Because by their actions they're proven that they didn't know your intent, and now you're coming in saying, hang on, you made a mistake, here is my intent. Because
I've got your contract here, I'm at the bank, and it's like, well, based on the signature that you signed, which is the only evidence I have before me, how could I possibly construe it any other way?
My intent is different. Here's my
record. That's fine. So it still gets back to my principle. It only matters from now and forward. That's my whole thought. I still just feel potentially like why create a potential thing? Like I said, because if you try to go back to the original signature, somebody very sharp might think of it as a kind of con, because potentially then all the way they've been handling up until now, they might be liable for all kinds of things, service charges and all kinds of stuff that they shouldn't have been applying to you. Who knows? And why create?
They are liable.
Yeah, but
because it's trust all along.
If you say, Shane, if you say it's my mistake, they're going to construe that you don't know what you're doing.
Yeah, I wasn't the one suggesting to say it was my mistake. That's what I'm saying. I wouldn't say that.
Well, you may have misconstrued my intent. It's more better because that means that they're still liable, and you haven't accepted the liability where you just let them off the hook using the mistake.
Yeah. I just want to keep the focus.
You misconstrued it, my intent, and now I'm correcting my intent, and this is what it is. This is the declaration of my intent.
Yeah. I just think simpler, you're trying to get one objection. You don't want to get into all the possible permutations, and again, because that kind of dilutes your communication. But if you just all you're trying to do is achieve one thing there, right? Establish that trust and have record of it.
But whatever I come up with, that's going to go in with my instructions, right?
Yeah, notice of declaration of intent. Or notice of declaration of trust.
Okay.
That should be the title of it.
Now, notice of declaration of trust. Yes, so notice of
declaration of intent.
Okay. Christian, would it be worth naming it as a special trust?
You could put special trust in there, because everything we're doing is special.
Yep.
Okay, notice of declaration of special trust.
Okay, that'll be easy. Question, I have a question. Yeah, go ahead.
Yusuf, I Chapter 7 about a year and a half ago to stop child support and student loans and stuff like that. So the federal judge gave me a discharge, but the child support, they're still taking out money out of my check every month. Can I say that y'all breached the trust and put something back on them?
Yeah, but that's a form of trust first, and then get them in a breach of trust.
So do the same thing that this guy was talking about. Just send another copy. Good. All right, thank you.
Why would you not want to take care of your child?
Well, the thing is, I don't have a problem taking care of my child, but I have 3 other kids. I have 3 kids altogether. There's one order. They're making me pay $700 a month for one child. And I feel as though that's too high.
Make a payment by titles.
Okay.
They'll have the money then. Do a special deposit.
Okay.
The reason why I say that, I'm not trying to place judgment on you, is that give them what they want.
Oh yeah, I mean, like I said, I don't have a problem taking care of my child, but the thing is, the mom ain't doing right, and I'm still giving my son money on the side and stuff like that, so I know that she's not giving him any money. So I feel as though for me to stop that car payment, 'cause that's what she's using the money for, I'm trying to do the best thing for all my kids. Like,
Well, CW, I don't mean to interrupt you, but something just came to me. CW, can't he ask for a new trustee, and that this money that he pays goes directly into a special account, and have the trustee watch over the account and make sure everything is done properly?
That sounds good.
And instead of going in there and being aggressive and trying to create a problem, what you're doing is solving the problem that from what you see, and say, hey, you move the titles and you order a new trustee of the trust, and then they can basically oversee and make sure that child is properly taken care of. That way the mom isn't, taking the money and going buying her a new dress instead of taking care of the little one.
Well, that sounds good. I like that.
Well, there's another problem with my research in that particular area. Most of that money is being diverted into the pockets of the government, and what residue of money that's being given to the mother is a lot less than what he's probably paying into the system.
Yeah, but the thing is, they're doing that through his signature. The money still goes to the mother, the $700 a month. But what they've done is that they've fractionalized it, and they're making money on the side, and just basically say, you guys can keep fractionalizing. I don't give a hoot. What I want you to do is to take care of the child, and I'm appointing this new trustee to, you send the money to this trustee, and this trustee would disperse the funds.
Right.
Can that be done, CW?
I don't see why not.
So in other words, you're actually moving the titles of this trust, and you're creating a new trustee, someone that you can count on, someone that, itemizes things and has it broken down and what the mother needs for rent or whatever the case may be, and you make it fair. Because you are the head of the household, and you are responsible. And I know you want to be responsible from what you said. It's just that basically they're taking to the cleaners.
Yes.
And that way the child being taken care of in the proper way.
Yeah, that sounds good. I like that. Thank you.
Well, great Yahweh.
Okay, it's about 20 after. Anybody have any more questions? I think we're going to cut off tonight. see you tomorrow night at 8. Okay. Thanks a lot. All right, Floyd, take it easy. Good night, everyone.
Good night, Chris.
Good night.